In the legal drama between Blake Lively and Justin Baldoni, some major developments recently happened. And I'll be real with you, it's not good news for Baldoni. In an opinion filed on Monday, June 9th, Judge Lyman dismissed all of Baldoni's claims against Lively, Reynolds, and the others. And he dismissed a good portion of them without leave to amend. This means, the judge said, Baldoni can't change his pleadings to fix these issues and refile these claims. In other words, they're basically gone for good from this litigation. Now, this is obviously bad for Baldoni. One of the claims dismissed without leave to amend was the defamation claims that we have been talking so much about on this channel. However, this fight appears to be far from over. So allow me to white pill a little bit here for those of you who are disappointed by this dismissal. Although there is certainly plenty of bad news here, it is not all doom and gloom. And in fact, there are some potential benefits to this happening for Baldoni's side. Now, this is a massive topic, so there's absolutely no way that I can cover all of this adequately in a single video. This one alone is going to be a doozy, so I had to break it into subparts so that I can say what I really wanted to say here. So here's what I'm going to do. In this video, I'll explain what the judge decided and why. These are going to be the main highlights. Remember that this opinion is like 132 pages. But in the next video, I'm going to talk about why this dismissal, in my opinion anyway, really isn't as bad as so many people think it is. And then we'll talk about how, in the long run, this actually could ironically end up potentially hurting Blake Lively's claims in her case. Let's get into it. Okay, so as always, if you are new to this case, there is a link in the description below to a playlist of videos that we have already done on the subject. So if you need to get caught up on this whole saga, be sure to go there first. Otherwise, let's dive in. But before we get into that, I have to thank this video's sponsor. This video is sponsored by Raycon. This summer, Raycon's everyday earbuds are the perfect accessory for all the things you want to do, whether you are outside to soak up some sunshine or inside to beat the heat. Either way, enjoy premium audio everywhere you go. They come in a spectrum of vibrant colors, including this green pair that I have here. They also have a really long battery life, 32 hours on a single charge. And when you do need to charge them, it just takes 10 minutes of charging to get 90 minutes of battery life. And you can charge them wirelessly with the earbuds protective case cover. For my part, I like to use them when taking Baby Bites and Indy out for our daily walks so I can listen to some music or maybe a podcast. And with awareness mode, I can do so safely while maintaining situational awareness. And then when I come back home to get back to work, I can turn on the active noise cancellation to get right back into focus again. And while I'm listening, if I need to switch quickly between my laptop and my phone, I can do it easily with multi-point connectivity to pair with two devices at once. So if you want to support the channel and treat yourself to an affordable option for your music, podcasts, and more this summer, go to buyraycon.com/legalbytes to get 15% off Raycon's everyday earbuds when you use the code Legalbytes. And thanks again to Raycon for sponsoring this video. Okay, back to the video. As I said before, on June 9th, Judge Lyman issued an order on all of the motions to dismiss the Wayfarer party's First Amended Complaint. And in that order, the judge actually dismissed all of the Wayfarer party's 6 claims against the Lively parties, which includes the New York Times. Here are the claims: civil extortion, defamation, false light, breach of implied covenant of good faith and fair dealing, tortious interference with contractual obligations or with a future economic relationship, and promissory fraud and breach of implied contract. Now I'm going to go through all of these a little bit out of order in order to make it a little bit easier to explain it. So let's start with the last one, promissory fraud and breach of implied contract. This was Baldoni's claim against the New York Times related to the noon next day deadline to provide comment on what we'll call the CRD complaint article they published in December 2024. Specifically, Baldoni said that his team received an email from the New York Times asking them for comment on the pending article. And they said, "We'll give you until noon tomorrow to provide comment for us." Then Baldoni's team gave a legal comment in response, but they didn't say anything like, "Hey, we're saying this for now, but we really need that full time until your deadline to look into things and provide a proper full comment." And when you look at this long paragraph, by all objective appearances, this looks like an official comment crafted in response to the article and intended to be placed for publishing. But here, Baldoni and the Wayfarer parties were claiming that this exchange created an implied contract contract between the New York Times and the Wayfarer parties. And so when the New York Times went ahead and decided to publish the article at like 10, 11 a.m. as opposed to like noon the same day, which was the deadline that they had given them to be able to provide a full comment, Baldoni and the others argued that this was a breach of an implied contract. Or at the very least, they said that the New York Times engaged in promissory fraud. And I will say, I have up until now been primarily focused on the defamation claims in this case just because of how massive all of these allegations are. But ever since the beginning, this claim to me personally has always been Baldoni's weakest one by a mile. First, let's talk about the implied contract part. When we're talking about any kind of contract, written, verbal, implied, there are certain things that need to happen in order for a contract to officially be formed. These aren't technicalities. These are foundational elements that are required in order for words essentially to become a legal agreement. The biggest pieces are offer, acceptance, and consideration. Offer and acceptance are generally fairly easy to understand. As an example, one side might say, hey, if you promise to pay me $50, I'll do this task for you. That's an offer. And so if the other side says, sure, no problem, then you have acceptance. If, on the other hand, the other side says, $50 is way too much, I'll give you $40 for it, then that's a counteroffer. And if the original side then says, okay, $40 it is, then they are the one accepting the counteroffer. Now, consideration is something that requires a little bit more explanation, but it's essentially the thing that either side is giving up in the exchange. In the example that I just gave, one side is promising to do a task. They're giving up their time, their effort, their labor. The other side, on the other hand, is giving up a payment of money. So there's an exchange of consideration in that example. But if one side is giving something up and the other side isn't giving anything, then you have essentially a gift. It's not a contract. But it's not always labor and money. Consideration can also be essentially an exchange of goods. It's like playing the board game Settlers of Catan. One party can trade 2 sheep for 1 iron ore. That's an example of an exchange of consideration. Now, sometimes you can also even buy a promise by the other side to do something or not to do something. And this means sometimes around a certain contract, you can even have layers of agreements. Let's take another example. One side can offer a whole shipment of lumber for a certain price. And the other side might think, I want to buy this lumber for this price, but I don't really need it until a couple months from now. And what if in that time the price comes down? So they might try to make a separate agreement where they pay the lumber company an extra fee to hold that offer open to them and them alone for a specific period of time. This way, the company that is buying the lumber doesn't have to commit to buying the lumber at that price right away, and they've essentially paid the lumber company to lock in the original offer price. So in that agreement, the lumber company's consideration is the promise to hold that offer open to the buying company for that specific amount of time. And the buying company's consideration is the payment of that other fee in order to hold it open. Now note that if they don't make this separate agreement where both sides are exchanging some kind of consideration, a promise for a fee, the lumber company is under no obligation to hold that price to that original buyer. So if they say, we'll sell you this lumber at this cost, and then the buying company is like, I don't really know, we might want to buy it, maybe not, then the lumber company can say, all right, I'll sell it to these guys. They're willing to buy it at this price right now. And then if that first buyer then comes back months later and says, wait, no, I want it at that original price, the lumber company could just come back and respond, sorry, we sold most of our lumber at that original price months ago, and now we actually kind of have a shortage of lumber because there have been a bunch of wildfires in the area, and we sold so much at the same time, so the price is actually way higher now. Because those two parties were still essentially negotiating, there wasn't any kind of an agreement between them, no consideration was exchanged, the buyer can't really sue the lumber company to enforce that original price when the buyer was the one that was being non-committal. And like I said, nothing was exchanged, nothing was really agreed to. So bringing this back to the New York Times claim about this offer of waiting until noon to publish, they gave the Wayfarer parties a deadline to respond to the article in order to provide a comment. And Baldoni and the others in this complaint said that this was some kind of an offer that they relied on to provide comment. And so when the New York Times published a couple hours early, Baldoni and the others argued that this was a breach of an agreement between them. But But the first problem is that there's been no exchange between the two parties to enforce that deadline. In other words, the Wayfarer parties didn't give up anything to hold that deadline in place. Like if they had planned to come out with something on social media, for example, to get ahead of the article or something, they could have said to the New York Times, hey, we promise not to post anything to pre-break your breaking story on this, so long as you give us the full time period to respond and maybe even amend any of our comments we give you before this point. Because that's the kind of thing that maybe the New York Times would have maybe cared about. But like I said, there's been no exchange of consideration. Neither side was giving anything up here, not materially anyway. And neither side really agreed to any sort of like general consensus on this issue. So really, there is no contract in any kind of form here. And if you think about it from the New York Times perspective, they said, we'll give you until noon tomorrow to provide us a comment. Then apparently at 2:16 a.m. or around there was when they received the comment from the Wayfarer parties. I mean, it sounds like they provided a statement that actually met the deadline. And so if you're the New York Times and you don't have anything from them that's also saying, hey, this is our comment for now, we still need more time, then for all you know, this is the comment that they intend to publish. So in that case, if you already have the comment, they met the deadline, you've got a couple hours to spare, why wait until noon to publish if you gave them that full and fair opportunity and they ended up taking it? Anyway, so this claim was totally dismissed, and honestly, people might be mad about this, but I actually agree with this one. Like I said earlier, this was far and away Baldoni's weakest claim in this entire complaint. Okay, so now let's turn to the contract claims against Lively and Reynolds. So there are two of them: breach of implied covenant of good faith and fair dealing, and tortious interference with contractual relations / with future economic benefits. Let's start with breach of implied covenant. This one basically just means that in every contract, there's an implied agreement between the two parties. And this implied agreement is basically that both sides are going to act in good faith to carry out their side of the bargain. So let's go back to that example of one side paying the other side $50 to complete a task. Maybe the paying party made a partial or even full payment upfront for the completion of this task. But then let's say the laboring side has absolutely no intention of ever performing that task from the outset of this agreement. And they just kind of start making excuses for not doing the work, and this turns into delays, and they start making things very, very difficult for the overall project. And now this creates more problems for the paying side. Maybe the paying side had other tasks that their business was relying on that need to build upon the performance of this particular task. And so this could turn into a claim that the laboring side was not acting within the requirements of this contract in good faith. And here, Baldoni and the others claim that Blake Lively essentially was a bad faith actor in the context of their agreements for her performance around production and promotion of this film. They point to all kinds of things that she allegedly did, like making threats, seizing creative control, and depriving the Wayfarer parties of the opportunity to produce, edit, and market a film as contemplated by the contract. But the court said there was a problem with their pleading on this claim. Particularly, they didn't really clarify what exactly the agreement was between them. In other words, what were Lively's obligations and what were Wayfarer's obligations? What were the benefits that Wayfarer contractually held under this agreement, which Lively allegedly tried to undercut or wrest control of in bad faith? And I'll admit, that was something that was actually pretty fuzzy in Baldoni's complaint. We have all of these complaints about Lively's behavior on set, during production, during promotion, etc., but all of that needs to be anchored in what were each side's obligations throughout production and promotion, etc. Now, one of the complicating factors here for Baldoni is the fact that it sounds like Lively never actually signed her contract when she joined the project. And I will say, considering the millions of dollars involved in this project, it's kind of insane to me that Wayfarer would allow that to be the case and still move forward with working with her when she hadn't signed it. Like, that's a lot of money to be spending where you're not dotting all your I's or crossing all your T's. So let me just say generally that the best practices are always to make sure that paper is in order. You hire someone for a project like this, you put a contract in front of them, and you have them sign it. If they don't, then the day before they're supposed to show up to work, the day that they do show up for work and everyone else is standing there waiting for them, you tell them that you are waiting for them to sign that contract before you continue anything with them. Even if it means having everyone on set staring at this person saying, "We're waiting. Why aren't you signing this contract?" It might waste a lot of money, but in the long run, it can end up really, really protecting the producers, the production, everyone else involved in this film. But even though she didn't sign it, that doesn't mean that there isn't an agreement in existence that they can hold Lively to. There are multiple ways of showing that they did, in fact, have an agreement that everyone was entered into. For example, this could be in the form of an email exchange or a text message exchange. They can go back and forth and say, hey, we'll pay you X amount, and these are the obligations that we expect from you in return. And then the other side can respond with an email or a text saying effectively, sure. Even though that's not a formal contract, that technically is an agreement that is in writing. But you can even have a verbal agreement that is confirmed in writing. This would be where Baldoni and Lively had a phone conversation where they went over all of the promises and obligations by both sides. Then one of them could follow it up immediately with a text message or an email or anything in writing that says essentially, hey, this is just to confirm that we had this conversation over the phone and this is what we went over. I agreed to do this and you agreed to do that. And if there's anything that I just said that is inaccurate, or if I left anything material out of this, please respond in writing within 24 hours, or I will presume that you agree with how I just laid everything out. So then that gives the other side a fair opportunity to respond by saying, actually, you left this one detail out. Or actually, that was inaccurate. Here's what I agreed to over the phone. Or they might just come back and say, yep, thumbs up. Correct. Let's move forward. Or maybe then they don't respond at all. And because you have that last clause in there saying that, if you don't respond, I'm presuming that means that you agree to it, then you have effectively an agreement in writing. Obviously, so long as this is a mode of communication that you can reasonably expect them to have read and understood and be checking on a regular basis. But even without something like that, taking it back to this current situation where supposedly Lively was handed a contract and just never signed it, if she then verbalized and more importantly, acted in conformity with those terms, even for a period of time, that can also be considered acceptance by performance or by conduct. In other words, maybe she gets handed this contract that has a bunch of terms, which include, hey, you need to show up on this day and put in this much work and do X, Y, Z. And maybe she doesn't sign it, but she shows up on that day and puts in that amount of work and does X, Y, Z. That can potentially be determined as acceptance of that offer through her conduct or through her performance. And so here what the Wayfarer parties need to do, according to the judge, is to give more detail about what the agreement was between Lively and Wayfarer. What were her obligations and her promises, which she allegedly later frustrated? And because the Wayfarer parties apparently said in their arguments over this whole dismissal issue that they can give more detail on this, the judge is giving them another shot at this claim. And that's an important detail here because it looks like the Wayfarer parties did not do that for all of these claims, and that may be a big reason why he dismissed so many of these with prejudice. But anyway, this is one of them that they actually can come back and amend, and partly for that reason. And that's a really good thing for Baldoni because it means that all of those allegations about Lively's behavior during production and up through premiere, how she allegedly threatened, seized creative control, and essentially stole the movie from Baldoni, of course, all according to his allegations, all of that remains in play in this litigation so long as he can clarify the terms of that contractual agreement, whether that was verbal, implied, etc. Now, because we haven't seen them yet, we really don't know how strong this claim will be until he amends the complaint. So I definitely will be looking out for this to see how things look once he does by the June 23rd deadline that Judge Lyman gave. Anyway, that's the breach for implied covenant of good faith and fair dealing. Next, let's talk about the tortious interference claims. Specifically, these are tortious interference with contractual relations or with a prospective economic advantage. This basically means that Baldoni says that he had an agreement with a third party, that is WME, and Lively and Reynolds intentionally interfered with that agreement by telling WME that Baldoni was a quote-unquote sexual predator. One of these claims basically says that there's an agreement with real-time present interests, and the other one is for an agreement that was supposed to provide economic benefits to Baldoni in the future. So that's why there's part of this is for contractual relations that are current, and the other one is for prospective economic advantage. In other words, future economic benefits. So there's a lot of overlap between these two claims, which is why the judge basically put them together when talking about them. Anyway, here Baldoni alleges that he had an agreement with WME to represent him, and that Lively and Reynolds interfered with that agreement by making threats to convince WME to drop Baldoni. Now, just like the breach of implied covenant claim, Baldoni really didn't plead all that much of anything about his contract with WME. So the judge said if there's no allegation that they have a contract, the claim needs to be dismissed. Now, the judge also found other issues with their pleading here. For example, the behavior by Lively and Reynolds needs to be independently wrongful or unlawful. And so the judge wants to see clear pleading that this statement was maybe, for example, defamatory. Now, like the breach of implied covenant claim, the judge is allowing Wayfarer parties to amend this claim because there's an indication that they can do so with more detail about the agreements between the parties and whatnot. But given that Baldoni's defamation claims were generally dismissed from this case through this order, and given that the statement that is in this claim, it was also one of the statements that was identified as allegedly defamatory, it'll be interesting to see what the judge says if Baldoni asserts through this claim in his second amended complaint that it was independently wrongful because it was defamatory. If I'm Baldoni, I'm going to be super careful and make sure that I very clearly hit absolutely every single element of defamation in my pleading on this issue. Anyway, that leads us to the other claims that can't be brought again. There's civil extortion, defamation, and false light. Let's start with civil extortion. This allegation had to do with Lively's and Reynolds' behavior around production, basically trying to steal the movie from Wayfarer. This is really all the same behavior that they complained about in the breach of implied covenant of good faith and fair dealing. The problem with this claim, though, is the issue over whether it's required for the plaintiff to show actual damages for the alleged civil extortion. Baldoni's side argued that they didn't need to show that Baldoni and the Wayfarer parties were economically harmed, that they had actual damages. But Lively's side argued that they did need to show it. And the court found that, yes, they needed to show actual damages. Now, the fight over this is centered on whether this claim comes from the California's penal code, the criminal law, or from common law. If it comes from criminal law, it means that you can say this situation is a lot like the criminal claim for extortion, which includes the possibility of a charge for attempted extortion, which is where the victim didn't actually give any money or any property over to the defendant. And when that happens, a defendant can actually be found guilty of attempted extortion so long as they've met all of the other elements. But here the judge said the civil extortion claim doesn't actually come from California's criminal code. Instead, this comes from the common law, and this claim is really more akin to alleging that the defendant induced a contract through fraudulent behavior or with some form of duress. And this means there has to be something the plaintiff actually lost as a result of the defendant's behavior in order for a civil extortion claim to be found. And so the court really went through some California cases in detail to show why a plaintiff alleging civil extortion needs to plead actual damages. Now, as I was reading this, it really seemed to me that Baldoni could potentially cure this if he made allegations of financial losses by his side as a result of Lively's and Reynolds' efforts to, let's say, for example, frustrate production. This would be things like maybe extra costs of production, extra time spent in production and in the editing process, things along those lines. And so it seemed to me that they should probably be able to amend this in order to, like the other contract-related claims, clarify the contractual agreements and obligations and rights between the parties, because the judge said that this was another issue with this claim, and to allege the economic harms that resulted from Lively's and Reynolds' behavior and how those economic harms benefited those two in particular. But in fairness to Judge Lyman, it looks like the Wayfarer party's legal team focused their argument on this claim entirely on the issue of whether or not they need to assert damages. In other words, they could have said, hey, we think we don't need to allege damages, but in the event that the judge disagrees with us, we are able to amend this to allege damages. This is something that happens in these kinds of arguments all the time in cases like this, and this would have tipped off the court that there's more that could be added, which means amending this claim would not be futile. But because it looks like they didn't add that alternative argument in their motions pleading, the judge basically said, You didn't give me anything to indicate you might win if I were to give you another shot. And so because of that, he's not giving them an opportunity to amend it. And honestly, this could be because Baldoni and the Wayfarer parties actually didn't have any monetary damages resulting directly from this behavior. And if that's the case, it does seem that that probably is the right decision here by the judge, as much as people probably don't want to hear that, to be honest. Okay, so on to the last couple claims that the judge covered in this order. False light and defamation. When the court talked about false light, he basically said that under California law, it's like defamation 2.0. So he dismissed the false light claims for basically the same reasons that he dismissed the defamation claims. So let's talk about defamation. If you've been watching all the coverage of this case on this channel, you know that I've talked about the litigation privilege and the fair report privilege. The litigation privilege, in a nutshell, is basically the idea that if a plaintiff sues a defendant for defamation for statements that they made in some kind of a legal proceeding or a court document, what have you, then the statement is totally immune from a defamation lawsuit. And there are public policy reasons for why that is. I've already gone into detail about that, so I'm not going to get into all of that here. But anyway, at the same time, then there's the fair report privilege. It's essentially a protection for media and journalism outlets who provide fair and accurate reporting of the courtroom proceeding, legal filing, etc. And under California law, the fair report privilege also actually extends to the parties to the litigation themselves who are supplying a copy of, say, a legal filing to the media so that they can report on this. Now, note that this is not the case everywhere. I've talked about this as well. In other states, that simple act of forwarding a copy of a legal filing to anyone else in the media or to some journalism outlet, what have you, is enough to destroy any protection that you have as a litigant. But California is fairly unique in that it recently explicitly extended that protection. Now, looking at them together, these are two legal arguments that I said from the outset were a potentially powerful tool for Blake Lively against the Wayfarer party's defamation claim, particularly when it came to any alleged defamatory statements coming out of the CRD complaint itself. And that proved to be correct here. Now, there are parts of this decision that actually surprised me and which I do disagree with. But when it comes to dismissing all the defamation claims for statements coming out of the CRD complaint, that's basically what I thought would be the case. I said before, any allegedly defamatory statements that come out of the CRD complaint are likely to get tossed. But if you've been following this litigation closely, you might remember that in the motion papers, Baldoni's side said, well, we're suing over statements made behind closed doors between Lively and her team and the media. And I thought that's a really creative argument because even California's extended fair report privilege has its limitations. And if Lively is making statements beyond simply, here's a copy of my CRD complaint, take a look and do whatever you want with it, and instead they are engaging in extensive additional statements about the allegations, then there's a possibility that we've got some defamation claims here that fall outside of these privileges. And looking at this, the judge could have leaned one way or the other. One way is in favor of a more liberal pleading standard that says, okay, you've pleaded enough circumstantially here that there's enough there, that this survives long enough for you to find out whether or not you can prove it with actual evidence. And the other way is to say, no, you still need to state what the defamatory statement was in order to sufficiently plead defamation because the defendant is entitled to notice of what they said that was allegedly defamatory. And here, the judge landed on the latter. Now, a lot of people are crying foul about this dismissal, but honestly, I'm not one of them, even on this claim. I thought this argument by Baldoni's side was an interesting one for sure, and I thought that it had possibility, but it was never a rock solid argument. And in hindsight, I think this outcome is probably correct because the defendant really is entitled to notice as to what it is that they said that was allegedly defamatory. There's really just not enough in this complaint to provide that notice, to be honest with you. But if at some point in the future they come across information that they find statements that do appear to be defamatory between Lively and her representatives and the media, that could bring brand new claims that are not tied to the CRD complaint themselves, et cetera, et cetera. And aside from that, if you think about it, if the judge were to allow Baldoni's side to move forward to essentially fish for statements when they don't even know what, if anything at all, was even said, this could start to chip away at these privileges, the fair report privilege and litigation privilege. And the California legislature has made it super clear that they intend these privileges to be strong and taken seriously. And anytime a legislative body makes something like that very clear, in any sort of legislation that they enact, judges are going to look for that kind of signaling to determine which way to lean if there's any ambiguity at all. But now here's the part that I did disagree with. I said in a recent video that I thought Blake Lively could totally be held responsible for the statements of Sloan and Reynolds if an agency relationship could be established. In hindsight, the Wayfarer party's allegations in the complaint could and should have been tighter to ensure that they had a factual allegation for every single element of the claim, including this one. But given the liberal pleading standard for complaints, I thought the argument regarding Sloan's comments in particular were strong, since Sloan is Lively's publicist, and publicists are hired for the express purpose of making statements to the public on behalf of their client. In this way, the role is very similar to a lawyer making statements to the public on their client's behalf regarding legal matters. And as I've pointed out before, Blake Lively's side has a defamation claim using Brian Friedman's statements made on behalf of Justin Baldoni and the other Wayfarer parties. And to me, both sides on this particular issue are fair game. But here, the judge found that the Wayfarer parties did not plausibly allege that Lively is responsible for Sloan's statement. Particularly, the judge pointed to the essential element of Lively's level of control over Sloan's statements to these reporters. Specifically, he said there are no allegations regarding Lively's control or lack thereof over Sloan's text messages with reporters or any other communications. And he said the fact that Sloan is Lively's publicist without more suggests that Lively controls the direction of Sloan's communications generally, but is not sufficient to support that Lively controls Sloan's word choice in each text message. However, I personally think this is the judge getting too nitpicky on this, and here's why. Sloan is Lively's publicist. That's what her job literally is to serve as Lively's mouthpiece to the public. And the judge pointed out case law that says, although the precise details of the agency relationship need not be pleaded to survive a motion to dismiss, sufficient facts must be offered to support a reasonable inference that an agency relationship existed. And I personally think that this complaint does support that kind of reasonable inference. In my opinion, it doesn't take a logical leap to come to the conclusion that someone whose job is to speak to the public on behalf of their client has authorization to say the things that she's saying on or off record if she doesn't say, I don't have authorization to make statement on this. And so I think that it's possible for the Wayfarer parties to come back and more particularly allege that Lively had awareness and control over Sloan's statements to the public in these instances. And even still, looking at it, I didn't really think that they needed to more particularly allege that anyway. And although Reynolds isn't hired as some sort of publicist on Lively's behalf in the same sort of way, I do think that it's totally possible for Baldoni's side to highlight how much of an overlap Lively and Reynolds have had in their work to show a partnership that isn't just marital, but is also professional. And this could create a scenario where either one has authorization to speak on behalf of the other. Now, at the same time, though, I will say that I feel much less strongly about this one than the Sloan statement because it takes more of a showing than what I think is already alleged in these papers to get to that conclusion. It's not like Reynolds has publicly been officially hired to be Lively's mouthpiece. So without a more specific factual showing, this claim was admittedly more vulnerable to this kind of conclusion by the court. But what's frustrating to me is that I can see how this can be cured. But again, it looks like Baldoni's side didn't clarify that they would be able to cure it when they were arguing over this motion. And that I think is an important flaw on Baldoni's side that ultimately bit them in the behind. But anyway, this video has been a long one, but I really wanted to ensure that I went through this dismissal order in an organized fashion and as complete yet succinct as possible so that we could really go over the nuts and bolts of it. I know this wasn't the result that a lot of people wanted, but at the end of the day, it's not the worst result possible. And in fact, I think that there's plenty of fight left in this case between Lively's case as the plaintiff, as well as the claims that can come back in Baldoni's second amended complaint. So in the next video, we're going to talk about why I think this dismissal really isn't as bad as a lot of people think it is. And in the next one, after that, we're going to talk about how, oddly enough, I actually can see a way how this can end up hurting Blake Lively's case. But in the meantime, What do you think about all of this? Do you think that the reasons for dismissal were proper even if you don't like them? Do you disagree with the judge and why? Or are you happy with this overall decision? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.